everybody, and welcome to CrimCon. We're on the third day here in Stream 2. We have a couple of minutes here for our attendees to join in. While we're doing that, we do have one missing panelist. If you're a panelist in the attendee section, drop me a note in the Q&A, let me know, and I'll promote you up, and we'll get that sorted out. Another minute or two. Okay. Looks like we're stabilizing here on the number of attendees. So welcome. Welcome to CrimCon. We're here in Stream 2. We have a panel today on courtroom issues. We'll be proceeding in the order that's on the program. To let you know how this is going to work, each presenter will have 10 minutes. That 10 minutes is going to be fairly strictly enforced, and I'll let them know when they're running close to time if we have issues. As they're talking, when you've got questions, hit the Q&A button down at the bottom and type in your question. We'll get to as many questions as we have time for at the end of the session. So enter your questions as they come up, and we'll answer them at the end. We're going to start with a courtnography of plea bargaining in upstate New York, court observations and interviews with defendants, prosecutors, and defense attorneys. We'll go ahead and get started here.
All right. Can you guys let me know if you see the screen okay?
I want to make sure it's all and we can hear you.
Perfect. All right. So hi, my name is Reveka Shteynberg, and I'm an assistant professor of criminal justice at Cal State San Bernardino. Today, I'll be presenting on a piece of a rather large study examining plea bargaining in upstate New York. This research was funded by an NSF grant, which supported some truly amazing research assistants, so shout out to them. The majority of pleas, estimated about 95 to 99%, are resolved via guilty plea convictions, as we know. Compared to research on these more seldom jury cases, plea negotiations, and the entire pretrial process is essentially a big black box with a question mark. There was a wave of in-depth qualitative ethnographic and or descriptive research done on these processes about 40 to 50 years ago, but Feely, Human, Eisenstein, and Jacobs, all those great researchers did all these, but it's been largely unexplored since then. Prior research on plea bargaining and adjudication describes pleas as a byproduct of assembly line justice, bureaucratic institutions, and adversarial systems. And most of the research that has been done over the last 50 or so years has almost exclusively focused on urban and large metropolitan jurisdictions and looked at patterns at the aggregate level, was outcome as opposed to process-based, and discuss the pace of justice as more of an issue of time to disposition and the number of court appearances. More recently, in the last 5 to 10 years, we've seen a reemergence of more of these in-depth process level studies. So this is a study doing that at the more rural, small town justice level. This study is largely descriptive and examines how local legal culture and judge and attorney role orientations inform plea negotiations in county, city, and justice courts in upstate New York. When most people think of New York, they think of New York State, subways, big city buildings, right? The city. But more than half of the population in New York State lives outside of New York City, and justice is done very differently there. In fact, New York is kind of like a microcosm of the rest of the country, right? Think Middle America. In upstate New York, there are over 1,200 town and village courts, justice courts, more than 2,000 judges in those courts, and more than 70% of those are not lawyer judges. And so those judges don't need law degrees to be elected to be judge. There are farmers, there are hair salon owners, there's bankruptcy court attorneys, there's former police officers being these judges. These are generally micropolitan areas with a small city, so 20 to 25,000 people, and small rural town and village courts or villages surrounding these, some as just a few hundred people, maybe 5,000. Many of them are legal deserts and social service deserts. For this project, the overarching goal was to examine the law in action as opposed to the law on the books. We know what the law says about how it should work, but does the law in action work differently in urban versus rural areas? Data collection for this project involved two phases. Phase one is an ethnographic study of the research sites themselves. This is a courtnography. I coined the term courtnography for this study to describe the ethnographic study of the courts, involving both court observations and conversations, so field interviews, with court practitioners and courtroom work group members in 13 county, city, and town and village courts in counties A and B, which are pseudonyms. I conducted approximately 95 hours of court observation, 15 hours in county courts, 45 to 50 hours in city courts, and 35 hours in justice courts in each county. The courtnography observations and conversations were exploratory and served as a mechanism for learning about the local politics, customs, practices, and processes involved in the adjudication and negotiation of pleas, right? Things that you can't just download from the local CMS. In phase two, I conducted systematic interviews with 34 defendants and 28 defense attorneys and/or prosecutors across the two counties. Interviews with the attorneys were particularly unique because, as I found out in my courtnographic work, many of the attorney participants had experience working in multiple attorney roles, which is something we don't normally see in big urban areas. So maybe they were a part-time public or conflict defender, because yes, those do exist, and also a private attorney in a particular county and took on private cases all across a certain region. Or they were included on both sides of the adversarial system. Maybe they worked as a prosecutor in County B and then switched to working as a court-appointed and/or a privately retained attorney in County A. There was a lot of crossover. And as I conducted this work, I soon realized that the practices and social norms were extremely different in more rural and small town and village and city courts. As I recall, in one place I went there and they were like, "Oh, you're in the country now, honey." And I was like, "I'm in upstate New York," right? Like, from being from Los Angeles originally, I didn't understand that, but I quickly learned the difference, right? And remember, these jurisdictions that are normally not getting the kind of attention in research or even in journalism. This is not where reporters go necessarily to look at how cases are processed, but they do look like the courts in the rest of America. And I really do mean that. I mean, take a look at these demographics, right? Especially comparing these two counties. So they're comparable in population size and percent below poverty line. County B is slightly whiter and tends to flip-flop between Democratic and Republican leadership at the county level, with a larger leaning towards Republican and conservative leadership. Where County A has a public defender and conflict defender system as the primary indigent defense systems, with assigned counsel picking up the slack, County B is unique in that it relies on a part-time public defender and conflict defender system. So all defense attorneys in that county that represent indigent defenders also have private practices and thus private clients. But a central feature is the DA's office. In County A, they have career prosecutors. But in County B, they have a lot of political turmoil from Republican and Democratic leadership flip-flopping. And so I found that this was a result in why there was so much frequent turnover in the DA's office, resulting in lots of new and unexperienced attorneys, which reflected both the eventual pleas and the pace of justice in these courts and cases. Where there was frequent turnover, there was also a lot of cases getting dismissed because of timely, speedy trial issues. Also, because these counties were so close by, they tended to have a pretty large crossover in attorneys and resources, as well as a defender population crossover. In the public defender, conflict defender, and DA offices, both counties followed vertical representation models. If needed, newcomers were generally working city court and sometimes the busier justice courts. These were the intro courts. More experienced attorneys then focused on county court dockets and picked up one or more less busy justice courts into their rotations. The same general setup applied in the two DA offices. If a case that originated in a justice court were to be indicted or voluntarily waived up to county court, an attorney experienced in handling felonies would be brought in if needed, though sometimes an experienced county attorney handling a justice court case may be able to retain that case. In this situation, it was voluntarily waived up. This would generally mean that a plea agreement was negotiated and in place beforehand. This generally involved the city court or justice court and county court attorney collaborating when negotiating with the prosecution. If the case gets indicted, then the county court defense attorneys are briefed before taking over the case. For private attorneys, most of whom also did some assigned counsel in one or both counties, the case generally stayed with them. However, attorneys tended to pool resources when they could. So if they were part of a larger private office, they would get help on cases with which they were unfamiliar. Those who were in solo practice sometimes called up friends and colleagues with more experience for help or referred clients if it got past a certain stage. In fact, that led to a larger theme in my study, which several attorneys outright brought up when discussing their own role orientations versus others that they see in court. It was also a theme in defendant interviews. This was the difference between criminal defense attorneys who were trial seekers and those who were trial avoiders. The trial seekers were fine with plea deals, but they were also more than happy to take the cases to trial and prep their cases with that possibility in mind. On the other hand, trial avoiders were plea seekers. They wanted cases that would plea out. It didn't matter at which point, so long as it didn't involve them going to trial. Sometimes it was about the level of amount of work that they had to do, but almost always it was a reflection of their experience and comfort level with trial courts. Those with experience working in public defender offices were almost exclusively trial seekers, and it was clear from the interviews that their interest in gaining lots of experience with trials was a factor in wanting that job. Same goes for those who pursued prosecutor jobs. They wanted experience. Trial avoiders tended to be private attorneys who took on low-level cases, and they saw it as a good thing, right? They thought they could get these good deals, but when talking to prosecutors and judges, they were like, I know who these guys are. Why am I gonna, there's really not much of a reason for me to give them a better deal. I know they're never gonna go to trial. In fact, this resulted in another theme being done. So we know with the shadow of trials model, that the concept that parties strike bargains in the shadow of expected trial outcomes, in some ways that was true, but with a difference. It wasn't the outcome specifically, but rather the attorney that could get those outcomes. So there was a lot of court organization issues, and I don't want to get into this. So you guys can read these pieces, right? It was more assembly line justice at the county court level and more personalized boutique justice at the local court level. There was also an issue of lawyer versus non-lawyer judges. One quote, right? We have cop judges who are cops, lay judges who are basically the prosecutor's mouthpiece, and then we have lawyer judges who are judges. This resulted in a big theme that these areas are like the wild, wild west, and that these resulted in ping pong rulings because they just didn't have the experience level. So it was more about leveraging role orientations and that priming defendants and clients about their experiences actually really worked and helped them understand and relay how their experiences could help. So it was really just about selling themselves. And really the biggest takeaways here is that local legal culture matters, right? We have to study these things to be able to understand the processes and how we can inform how we do big aggregate level studies. So thank you guys so much. I am going to stop it there. If you guys have any questions, please let me know. So thank you.
Great, thank you so much. Reminder while our next presenter is getting ready, you've got questions for our presenters, hit the Q&A button down at the bottom and type your question in the box. We'll get to as many questions as we can. Also, if you're the other presenter on this panel, drop me a note there and we'll get you promoted up. The next paper is Type of Pretrial Release and New Criminal Activity.
Okay, well, thank you. My name is Jamie Vaske. I'm presenting this on behalf of my colleague Troy Payne and Jessica Smith. So before we get started, I just want to kind of give you a little bit of a background on why we decided to do this kind of work. In 2015, the Chief Justice in North Carolina basically commissioned a series of judges and stakeholders together and said, how can we improve processing of cases in the criminal justice system? And they said, let's focus on pretrial reform. And this really kind of laid the foundation for stakeholders to start thinking about, like, how do we focus on the pretrial process? So fast forward to 2018. In 2018, my colleague Jessica Smith, she wanted to look at how secured bonds were issued in North Carolina. And this was important because North Carolina general statute says that judicial officials, they must impose a written promise to appear or an ROR bond, a custody release, or an unsecured bond, unless certain conditions apply. And really those conditions apply if these bonds will not ensure the appearance of the individual, if they will continue to engage in pretrial crime, but otherwise really the default should be these non-secured bonds. Well, this is what she found whenever she looked at the types of bonds being issued for misdemeanors. For 78% of misdemeanors, they received a secured bond. And I focus on Forsyth because that's one of the jurisdictions that we are working in. In Jackson and Haywood, we see about 50% of misdemeanors are receiving a secured bond. So if the default is something other than a secured bond, and this is what we're seeing, then obviously something is a little bit off. Fast forward to 2019. 2019, there was a class action lawsuit filed against Alamance County. In November of 2019, 3 defendants basically filed a lawsuit saying that Alamance County judicial officials, that they were subjecting individuals to wealth-based pretrial detention practices. And in their complaint, they said that 88% of cases were receiving a secured bond. So obviously those other conditions are not the default. And they also said that magistrates were not taking into account individuals' ability to pay. Instead, what they were doing is they were setting secured bonds basically based upon the highest offense class for that series of transactions. And this is really similar to what we see across other jurisdictions. But what was really interesting is that a lot of times magistrates, they were not even talking to defendants and saying the conditions. And all of this kind of set in motion stakeholders really taking into account, how do we improve our pretrial processes, not only from a litigation standpoint, but also a justice standpoint. So around this time, my colleague, she started getting a lot of phone calls from judges, because she trains the judges in the state, and they wanted to revise their pretrial policies. The first jurisdiction that we worked with, they were not ready to embrace a pretrial risk assessment, so we compromised. I'll show you the framework here in a second. But the framework, it takes into account offense class, but it also takes into account a range of defendant and charge-based characteristics, as well as those statutory requirements that I mentioned before. Here's just a very short view of what the structured decision-making model looked like. So it starts off with the offense class. If it's a class through A through E felony, which is the highest felony in North Carolina, then the person goes down to the statutory requirements. If it's a misdemeanor or an intermediate or low-level felony, instead the magistrate goes to this middle box, and they take into account a range of defendant-based characteristics. So do they have insufficient ties to the community? Legal characteristics, have they had a pattern of this in the past? Is there a weapon involved in the offense? If none of the boxes are checked here, then the judicial official goes over to the box on the right, and the recommendation is to impose something other than a secured bond. The judicial official can impose a secured bond and record the reasons for doing so, but we really wanted to recommend following the statute. So timing of implementation or comparison groups, Judicial District 30B, which is Jackson Haywood counties, in 2019, that flowchart was implemented. And then 2018 was our comparison group. For Judicial District 21, Forsyth County, we started implementing it in 2020, and 2019 is one of our comparisons, but with COVID, it's really complicated things. So we have additional comparisons in 2020 that are not implementing this, but today I'll focus on 2018. So let me give you an overview of the results. So first, what did we find? After the jurisdictions implemented the policies, we saw about a 13 to 35% decrease in the use of secured bonds. So a significant proportion more individuals were released into the community. At the same time, we saw that 80% of defendants did not get a new charge during that time period. And the most common charge that individuals did get was a traffic offense. Whenever we compared across time periods, we saw that new criminal charges during the pretrial phase or pretrial period, it only increased by 1%. So let's take a look at the individual results just really quickly. What we saw in Judicial District 30B, if we compared the whole time period of 2019 to 2018, we saw that the use of secured bonds decreased about 29%. There's about a 29% change. So we saw that there was 59% of cases that received a secured bond in 2018 versus 42% in 2019. And the same pattern of results emerged whether we looked at felonies or misdemeanors as the highest charge. What about criminal activity? What we saw again was about 80% of defendants did not incur a new charge. Whenever we looked at 2018, about 18% did, and that was only about 1% higher than what we saw in 2018. What about Forsyth? Forsyth, we're just starting implementation and evaluation. So these are some preliminary results. What you saw was during the first quarter of 2020, the percent of secured bonds decreased relative to the first quarter in 2019. We broke apart Q1 and Q2, obviously due to COVID, to kind of take that into account. When we look at Q2, we saw that the use of secure bonds decreased 31%. Now, this could be due to greater implementation, COVID, or a combination of both. We compared Forsyth relative to other medium metropolitan counties, and Forsyth did decrease much more than the other counties. So we do think it's due to implementation a bit. What about criminal activity? When you look at criminal activity during the first 6 months of 2020 relative to 2019, we see that it has only increased about 1%. Relative among individuals who engaged in new crime or had a new charge, we really see that the most common charge was traffic charges, and none of these changes were statistically significant. So we can effectively say that it looks like recidivism right now, very early on, is not significantly changing. And even though our time period was a bit different, here for 6 months relative to a year and 30B, again, it was a 1% increase. So what is our conclusion? We see that these structured decision-making tools, along with really strong leadership, it really impacts how these conditions of release are used at the initial phase or the initial bond setting. And I really want to mention this, the strong leadership. It's our superior court judges or district court judges and chief magistrates. They're really creating the culture to where this can be implemented. When we look at new criminal activity, it seems to only increase about 1% regardless of the data that we're taking in the time period. Our next steps, we're going to look at defendant level analyses to really kind of zero in on type of condition of release. And if someone gets a new criminal charge, that's our next step in our analyses. And policy-wise, we're really focusing on the ability to pay. In our initial conversations with stakeholders over this last report, they really wanted to take into account this ability to pay idea. The Alamance County settlement, they had really aggressive criteria that you had to meet in order to set a secured bond. So if you're a full-time student, if you have been in a halfway house or residential facility, then you can't afford to pay any kind of bond. And if you do get a secure bond, it can only be 2% of your income for that month. So it was really, really aggressive and brought a lot of attention to how do we assess the ability to pay. I expect that stakeholders will continue these conversations as we move forward. So here's my contact information. My colleague, Jessica Smith, she's really in charge of all of the policies that were implemented here. So if you have any questions policy-wise, she is a great person to go to. Otherwise, thank you so much.
Great, thanks, Jamie. We'll get to questions. Once again, you can ask questions by hitting the Q&A button down at the bottom and typing them in. We've got a question here. Could you speak some more to trying to get jurisdictions to implement pretrial risk assessments? You said one really wasn't ready.
Yeah, the jurisdictions that we were working with, they were not quite ready to implement a risk assessment. A risk assessment had just never been implemented at that phase. And of the assessment that they were looking at or considering tossing around, once we got into like, how do you pull this data when it's only state level and what's the validity of the data, they just weren't really fully convinced yet. So they felt like the structured decision-making was a good place to start.
Yeah, and I can speak to that from an Alaskan context. Here in the state of Alaska, a pretrial risk assessment was implemented, but it was done so in kind of an odd way. It was scored by the Department of Corrections and then sort of handed off to the court. And there were a number of implementation problems resulting from communication issues, training issues, that would have been a little bit easier to resolve if it had been within the court. I think there was a fair bit of just a little bit of interagency mistrust and just miscommunication. So it can be quite difficult to implement pretrial risk assessments, because you've got to do kind of a charm offensive for risk assessments, like the whole concept of risk assessment. You have to explain how it works, why it works. You have to demonstrate that it works. And there are a fair few actors within the criminal justice system that are resistant to the idea of a decision-making aid that can help increase the accuracy of prediction.
Yeah, I would say in the jurisdiction that we first worked with, they were a part of the conversation of what do you want to be in that middle box? What kind of defendant and legal characteristics are most important to you? And I think that sense of ownership and helping develop those factors help bring them into even, wanting to implement it.
Actually, it kind of reminds me a little bit of what happened in one of my courts. So in California, they obviously struck this down right in the last election cycle. They're like, no pretrial risk assessments. We're not going that way. In upstate New York, where I was doing this research, some of the courts were actually doing it very informally, which I thought was really, really interesting. They made up their own. In one of the counties, they actually had an investigator sitting in the city court and who would implement this risk assessment. And they were basically considered as part of the court, but it was the public defender that kind of like owned that position. And a lot of the smaller courts didn't have that capability, but some of the judges would basically adapt the questions from that and really kind of use it. Although they would still lean towards kind of going with whatever the prosecutor suggested. But they did kind of implement it in this kind of smaller way, which I think speaks a lot more to like how the risk assessment industry, the Arnold Foundation, who are big proponents of it, are kind of starting to educate and also convince people to start using these models, particularly since there's been so much bail reform discussions in New York, and like just general reforms.
And it impacts some of the other presentations that I've seen here during our conference, of just how we communicate results and how we communicate the science to practitioners and to the public. Here in the state of Alaska, there were a series of criminal justice reforms kind of all at the same time. And in the public imagination, it all kind of just got mixed together. And so there was just a flurry of news stories and a lot of conversation about it without a lot of research, because there just hadn't been enough time for us to be able to get in there and see what was happening. So it's a real challenge just on the communication side, even if you can get practitioners on board, and frequently they are, because they want to do a good job. Like I've never met anybody who works in the criminal justice system who wakes up every day and says, you know what, I want to do a bad job. That's just not the folks who tend to be in the system, right? So they want to do a good job, but we have to be able to talk with them in partnership to get it done. And it's a pretty serious challenge to be able to do, whether we're talking about risk assessment or other kinds of conditions, and everything else in the criminal justice system. It's hard. We also need to give them practitioners and policymakers tools for talking to the general public, because that's another hurdle, right? That even if something works and we can demonstrate that it works, if we can't do so in a way that resonates with the public, then political pressure can destroy it kind of no matter what.
Yeah. It's actually within the more rural context. I touched on it briefly. I didn't get into it as much as I wanted to. I wasn't sure if I had 8 minutes left or 10 minutes left, so I just stopped. But with that statement with the cop judges versus, lay judges, and, judges, the attorney judges, there was kind of a discussion of how the law enforcement officers versus the ones with no legal experience really didn't understand some of these more legal, like they couldn't make legal arguments to them. It was more kind of like how you would speak to a jury, right? Trying to explain things. Even if they were in the office for sometimes 20 years, they don't really have experience writing motions to that extent. And so oftentimes when you have these more technical data issues, right? Like what a risk assessment is and why certain questions have to be phrased a certain way, and why some questions are racist, or classist or sexist, right? They don't often understand the kind of the intricacies of it. Not that they don't want to, it's just that they don't have necessarily the legal or social science background. And so oftentimes there's kind of like this education that needs to happen. And they do take like CLEs, like lawyers do to some extent. But for judges, it's very, I mean, they basically have training for like 3 days before they become judges after they're elected. And if you're a farmer, I mean, it's great because you can represent your community, but how are you going to implement some of these other changes? How are you going to implement all these unfunded mandates from the state for reform when we don't really have the same level of kind of ability to demonstrate these things as maybe those who have prior legal training? I think that's another issue that kind of plays out in these more like rural areas where they don't necessarily have the capacity to implement all these things because they're funded by like traffic tickets and
Right.
Restitution if no one collects it.
Yeah, and just that, the complexity of the role of the judge. I mean, there's not a chance that you would be able to give me 3 days of training and I would be able to be a successful farmer, right? So it kind of works in both ways. Are there any other? Yeah, it's rough. It's I think one of the things that that this discussion and some others have really hit for me is that communication aspect and the translational research, the importance of that across the whole field, and making sure that we're keeping our audiences in mind and that we're producing products that are responsive to their needs.
Yeah, I mean, at the end of the day, the people who are trying to implement these things, right? Like a lot of times it's the policymakers who never talk to the people actually out in the field, right? Or they talk to just the people in New York City. And it's like, New York City's not upstate New York. Like people from the city are like, oh, I'm going to be in like, fill in the county. Like, can you show me upstate New York? And I was like, you do realize it takes like 6 hours to get from one end to the other, right? Like there's no subways. Like transportation is very limited. There's horse and buggies because there's a ton of Amish. Like people don't realize that you have to really talk to your audience when it comes to these things. So let me see. There's actually a question. Did a certain type of judge, lawyer, cop, etc., have more receptivity to risk assessments? I would say that those who were in the city and county courts tended to look more favorably upon the usage of them. They kind of just saw it as more of like a standard practice. Did they love it? That differed, right? There was a lot of political kind of differences, especially in places where it was more Republican, conservative versus Democrat. So there was a lot of kind of contention also with who implements these things, because a lot of these reforms are coming from the governor, Cuomo. And for those of you who are familiar, he rubs people the wrong way. Even if he has good intentions and it wasn't even his policy to begin with, if he signs off on it, sometimes people don't necessarily love that. And also any unfunded mandate, right? So city courts, county courts, they actually get paid to be there to a certain extent. These part-time judges, I mean, sometimes these courts don't meet every day during the day. These are night court judges, right? You may have just a few cases a month. You may meet once a month and have maybe 2 hours worth. Maybe you meet twice a week from like 5 to 7 p.m. or whenever the case docket ends. I mean, sometimes I sat in court and like it was 35 minutes and we were done. And then I had a long drive back without revealing where my sites are. And then in other places, it was like 4.5 hours and I'm there till 11 o'clock at night, right? But they don't really get paid a ton. It's like $3,000. They're doing it because they want to add to the community, or because they have a business and they want to be a central figure in the community. They really, they want to do well for their communities. And so whether or not they think risk assessments are good, I would say that the people who are kind of see themselves as figures of this community, so more of the town and court judges, I think that they do a better job than these risk assessments because they know these people, right? Like that kid in front of you who's the defendant, that's your cousin Nancy's sister student, and you know all about them, right? That's very different than in New York City where like Joe Schmo, right? Like if I know most of the people coming into my court as a judge, what's that risk assessment going to tell me? I already know their entire criminal background, right? Like a lot of people, there's a lot of conflicts of interest also. So like there's, which aren't necessarily conflicts of interest. And when you get rural, right, like you're a correctional officer and your family's the inmates, right? Like there's a lot of kind of crossover, and that's just a feature of small local legal cultures that you don't get at urban courts. And so like when we talk about, oh, that's a conflict of interest, it's like, well, good luck finding somebody that's not going to be a conflict of interest in a town of 500 people. Like seriously, right? But for these risk assessments, it really is whether or not they like it's more assembly line versus more personalized justice. Where it's more personalized, there's less receptivity toward it, and where it's more kind of assembly lines, some of these county courts or city courts, they're a little more receptive to it. So that was a long-winded answer, sorry. Let me know if you want to respond.
No, I mean, it speaks to the diversity of needs too, right? So like, even if we're thinking about the courtroom work group or judges specifically as the audience, the judges are differently situated depending on what court they're in, what geography they're in, what context they're working in. So it's, I mean, you know, we can sum up all of science by saying, yeah, it's complicated, but that doesn't help us to implement good policy. Yeah, it doesn't help us to implement good policy. But I think work like what we've seen in this panel really does help that, because it's a step towards being able to understand how to implement a variety of reforms that we have good evidence work. Any other parting thoughts? We have no more questions.
I'm curious, Jamie, what stuck out to you about your work? Kind of something that surprised you, that kind of maybe you were expecting, but you weren't, but there was like a twist. I'm curious.
I think for me thus far, the new criminal activity that has been interesting to see. I thought it would be a lot more. And the fact that we're implementing this across different jurisdictions, it's been really fascinating for me to, number one, see variation within a county across magistrates and judges. And number two, to look at the vast differences across jurisdictions. So I could get arrested in this jurisdiction over here for an offense, get a $5,000 bond, get arrested over here and get a $500 bond. And just, I mean, just the wide amount of variation in amount of secured bonds has been interesting.
Yeah, you know, I found a bit of similarity with that as well. There's definitely quite a bit of variation, especially I would say the law enforcement officers, the ones who became judges later, tend to give the highest bails and bonds. That was, everyone told me that, I saw that. Their courts were like militant courts. I thought that was probably the most fascinating thing. Like they ran. They had, you know, if they had security guards, which many of them don't, but if they did have court officers or bailiffs, I mean, it was like, don't chew gum. Whereas in the other courts, it's like people are just like on their phone, singing along, humming. City courts were, you know, a bit more kind of protocol-esque, but it's definitely interesting seeing kind of like these flavors of justice when it comes to setting bails and bonds and just who does and does not get those. And like, if I know that you're not going to appear in court because I've seen you a million times, how's a risk assessment going to play into it, right? Like, it just kind of interesting.
We've got a question that's along those lines. Can the panel speak to advice in taking these court differences into account when studying case outcomes or time to disposition data? Individual differences seem pretty challenging for aggregation.
Yeah, so it's complicated, obviously. I'm going to say that it depends on whether it's a city or a day court or a night court. So whether or not they meet every day, right? So in a completely unrelated study where I was studying with a group from Albany, the implementation of attorneys at first court appearances. So getting you an attorney at your first court appearance, right? One of the things that I kind of found through that study, in addition to this study, is that these night courts, if we just looked at number of court appearances, well, maybe they only appeared in court like 6 times, but that was over the course of an entire year because they meet once a month And that's just how it is, right? So sometimes they actually waive you up to court if it's like a low level or a felony, just so you could plea out in felony court in a low level felony instead of waiting a ton of time and getting a misdemeanor in town and village court, because having that case maybe prevents you from doing something, right? But having a low level felony maybe doesn't, especially if you're like a business owner and you're trying to get like a loan of some sort or something like that, right? So when we're looking at like studying case outcomes, you have to understand that how often courts are held really does impact these things. And when we're starting to get to these more rural areas, right, that has a significant difference. Also, most of these town and village courts are, or all of them, are not courts of record. So if I went to the Department of Criminal Justice Services in New York State and I downloaded all of the cases for New York, and I went to a county, let's say Albany County, which is where I was living at the time, it would only include cases from city and county courts. It would exclude all of the cases from town and village courts. So when I'm trying to get a picture of how the pace of justice and the outcomes look like in New York State, in these more rural counties, I'm only looking at the city courts. And yeah, they handle the vast majority of cases within the city and county courts, but I'm basically missing out on the entire picture of these rural areas.
Yeah.
And many people download these data sets and don't know that. They don't realize that. And so when they report these findings, it's like, here's how it is, right? And that's nice, but it doesn't actually paint a picture. And so you really have to understand the local legal culture. I mean, even if you can't actually go on the ground and do these ethnographic pieces of work, right? Call up the people who are actually doing the data, call these counties and just double check. I mean, ask them, right? Bring it back to the actual practitioners. One of the things I did with my work was I went back and I said, hey, am I interpreting this correctly or am I an idiot? Like, am I just perceiving this from my lens of social science? Is it just because I was, talking to these people instead of these people? Talk to them, present them with your preliminary findings and be like, am I doing this correctly? Because you're also representing not only these counties, but we're potentially impacting tons of policy, right? If we find something and we report it and some journalist picks it up, or it just becomes something that's dangerous, especially like now with all the media, right? So like, I think that that's definitely a challenge when we're aggregating data, is to just kind of try to personalize it a little bit and at least do some spot checking from kind of the local legal culture aspect.
That's something that we've seen across a lot of the data collection that we do, sort of, separate from anything presented in this panel, is that, in the Alaska Justice Information Center, we'll take big administrative data sets, we'll do a bunch of fancy pants data management and analysis on it. And then we need to make sure that what we're seeing makes sense on the ground, right? So we take that back to the agency. We work in partnership with the agencies that we're taking data from, and say, here's what we're finding. Does that sound about right to you? And sometimes the answer is, well, that's surprising, but now that I think about it. And sometimes the answer is, there's no way. And it turns out we've done something horribly wrong, or we've misunderstood the data generating process. And sometimes they have inaccurate, pictures of what their own data look like and what their own processes are. And all of that, like, no matter which of those it is, it's really important to get the feedback from the folks that you're working with, to make sure that it makes any degree of sense at all, and that ultimately the results are useful to policymakers, because that keys into that, right? If you go to a task force or commission meeting or the legislature or whatever, and you tell them something that just doesn't make sense, they're never going to believe anything else that you say. So it hits credibility as well. Thank you so much for this great discussion. I think it's a pretty good place to leave it. We've recorded this session. The session will be available on CrimCon's YouTube channel. You can find us by going to YouTube and searching for CrimCon. You can also subscribe to our mailing list. If you go to crimcon.org, scroll down a bit, you'll see where you can subscribe. Once we get all these posted, we will let everybody know. If you're in the session looking for the next set of presentations in this stream, we are going to end this webinar, which means it'll kick you out and you'll have to rejoin for boring technical reasons. I'd like to thank our panel once again for the work and for the conversation. This has been really great. Thank you.
Thank you for hosting, and thank you to CrimCon for giving a venue for such kind of recorded discussions as they are.
Yes.
This has been so much fun. You have no idea. Well,
Yeah.
you have some idea.
All right. Have a great day.
Thanks, guys.
Thank you. Bye.